Ladies and gentlemen, distinguished colleagues, first let me to introduce briefly myself. I'm Alexander Bělohlávek from Prague, Czech Republic, professor of international law and professor of international economics, attorney law, arbitrator, past member of the World Jurist Association in Washington, D.C., also past member of the ICC International Court of Arbitration, currently Vice President of the Permanent International Court of Arbitration at the Commodity Exchange. I first like to express my gratitude, and I'm very honored to be invited to this fora and to share with you some of my thoughts regarding the current situation in arbitration and the task of arbitration in respect to the very specific situation we are confronted currently with. Apart from the obvious practical challenges concerning the needs to adapt to various restrictions imposed by national governments as a result of the coronavirus pandemics, the arbitrators will likely be confronted with a large number of qualitatively completely new cases. The current situation severely interfered with the performance of ongoing contracts in almost all business sectors. What's new is the dynamics of the disputes, which differs from the cases the arbitrators are usually faced with. Here, the existence of fortuitous circumstances and how the governments responded to them will be in the center of the disputes, rather than intentional breach of contracts. The parties are likely to rely, for instance, on hardship clauses or force majeure arguments, which will be rebutted by pacta sunt servanda, rebus sit stantibus, or similar principles. The tricky part is that, unlike in other cases, both parties might be affected and will claim circumstances exonerating them from the liability for the breach of their obligations. Of course, the governmental restrictions and their effect on the objective ability to perform the contract will be tested. All that will have to be assessed, taking into account the terms and conditions of the contract that might stipulate rules governing the existence of or exempting from liability. However, it is to be expected that legal arguments used will far exceed the mentioned principles. These arbitral tribunals will be under pressure to prove to the public, which has been for some time confronted also with negative publicity concerning arbitration, that the so often mentioned advantages such as flexibility and expediency are real. The circumstances of the past months are so extraordinary that a strict adherence to the contractual terms and conditions won't be simply sufficient. The focus will have to be on the foreseeability and reasonableness of the parties' actions, including their duty to prevent and to mitigate losses and damages, as well as on proportionality and necessity of the measures taken by the governments. As already announced by many major companies, they will seek compensations based not only on contractual liability, but they will involve also the responsibility of the governments by putting into question their response to the pandemics. Jurisdictional issues and questions regarding arbitrability will have to be dealt with. in a way, I believe that this situation also presents an opportunity for the arbitral community to show that the arbitral community and the arbitration is better equipped to deal with situations such as this than probably the national courts do. While respecting the rule of law, arbitrators should provide the parties with dispute resolution that is fair and just and takes into account interference by the state and the parties had to endure. Considering the resources and technical possibilities available to the arbitrators, I hope that we will rise to the challenge and that arbitrators will be able to contribute at least partially to the resolution of the difficult situation of many entrepreneurs and companies. However, let me also to point out some procedural issues. Historically, has arbitration provided a tool of effective, fast and private resolution of disputes, where there was a threat that national courts will not be able to promptly and accordingly comply with needs of disputing parties. Core values of arbitration are on one side providing sufficient freedom to disputing parties while preserving seriousness and credibility of the proceedings, and providing expertise, experience and flexibility of arbitrators, while allowing also them to fully assess all relevant circumstances on the other. Almost 30 years of my practical and theoretical insight look into arbitration probably allowed me to witness many changes, tendencies, development, but of course also unfortunately steps back or steps, as from my point of view, in the wrong direction. Although it is my true and deep belief that arbitration should never give up on one of its major advantages, which is, among others, flexibility and the ability to provide parties with prompt but relevant and just award. Aspect of maintaining credibility and seriousness of the proceedings needs to always be taken into consideration. The word of our 21st century is without any doubt a word of rise of technology and globalization. The ability to reach others within a blink of an eye is something we as humanity couldn't imagine 10, but most probably not even 5 years ago. As this progress in many aspects is certainly positive and indeed appreciated, it is my belief that we should not approach it light-headed, and the adjustment of the institutes created many years ago to today's world should be made with caution and with respect to the core values of arbitration. Let me connect these thoughts with my experience from the last 30 years. Even though technology indeed made it possible for the parties to submit all documents electronically, and even made it possible for the parties, arbitrators and other participants in the proceedings to sit in front of web cameras and to hold proceedings online. With all the seriousness, I can say that I have learned that it is the possibility to feel the atmosphere in the hearing rooms, to shake hands with the parties, to look the person in the eyes, to see the mimic reaction of the parties, their body language, to be able to promptly react on anything that is happening in the hearing rooms. That is integral part of decision-making process, and that is something without which the arbitration would lose touch with its rules and core values. Recent global circumstances caused by the pandemic of coronavirus, as certainly and without any doubt hurtful and horrifying as they were, gave all of us opportunity to rethink and question our methods and ways. As for someone who is used to travel on a daily basis, it has been a time of unprecedented slowing down. Work, including work of arbitration, had to find ways how to carry on. I have seen and welcomed certainly many initiatives that could possibly outlast those hard times and lead into innovation even after recent events will hopefully become over. Yet I couldn't ignore the thoughts that despite the opportunity to innovate and progress, we should simply not forget our history and the core values, as I have mentioned, for only three with solid roots can grow tall. I would not dare to say that we should lock ourselves in a conference room, pretend that technology does not exist, and wait until arbitration gets obsolete and not suitable for latest demands of both parties and arbitrators. I believe that it's my role as a person with hopefully same experience to point out, or more precisely to offer my point of view. I believe that time may and most likely will come when technology will be able to supplement all that is so essential for arbitration, including all I have mentioned. But at this point, I must appeal on the arbitration community to sustain what's so inherent to meet what arbitration means. But let me also to point out an issue that weighs on me since many years as active arbitrator. This is the fulfilling of the main advantages which will be mentioned in the introductory part of almost all textbooks and treatises on arbitration. The speediness, expertise and cost efficiency of arbitration. The fulfillment of these prerogatives of arbitration will be all the more expected by the parties right now. Many companies and entrepreneurs have come to the brink of economic collapse. That's why they will expect a resolution of their disputes not within 1, 2 or even more years, but within a few months as maximum. It will be a matter of their survival. Parties will not expect to elaborate on hundreds of pages long submissions, extensive expert opinions, long, weeks-lasting hearings, documents production, extreme costs of the proceedings. The parties will expect that arbitrators will react immediately. For instance, they will call for hearing immediately. Rather than drafting guidelines and documents, materials, how to handle specific disputes in the post-pandemic time and creating task forces for it, we will be faced with very specific disputes, and it is my opinion that it is the time to opt for and to return back to very, very proactive and even investigative role of arbitrators. They are the parties who are appointing arbitrators. They are the parties who are putting their trust in the particular arbitrator. Once appointing or nominating an arbitrator, the parties must rely on the high professionality of arbitrators. Subsequently, they must be the arbitrator's task to decide on how extensive limits will be set for the parties. As of my opinion, in particular, the current situation is the right time to think about such measures, like to cut in a maximum extent the timelines, to think about a very proactive role of arbitrators in witness examinations, for instance, rather than to leave all the activity on the parties, to cut in a maximum extent limits for written submissions, not to admit evidently for the disputes not significant evidence, to call the parties that they will present their closing statements in the end of oral hearings verbally, and not by presenting their post-hearing briefs in written within weeks or even months after the oral hearings. I have to mention that I in person do remember that it was natural and it was a standard that the parties presented the oral hearings in the end of hearings, oral hearings. However, all that is nothing new. If you will ask any of our distinguished senior colleagues, arbitrators or senior professors, they will simply confirm that this is something which was a standard of arbitration a couple of decades ago. Even extraordinary, complicated cases have been resolved within a couple of months, even weeks within one-day oral hearings. Many people may argue that the world became complicated and that the disputes are significantly more complicated than they were in the past. Might it be? Even it is certainly not possible to generalize, and all the less to use such very generalized and, from my point of view, alibistic and in many improper arguments for justification of living the basic principles of arbitration. Nevertheless, the principles of arbitration didn't change at all. Principles of arbitration, which I have mentioned, and which are part of each textbook currently, are completely the same as we could read them in the textbooks published 50, 60 or even more years ago. And we have simply to return to the origins and to the methods and conduct which created arbitration as a recognized and generally accepted tool for resolution of disputes preferred by the broad international business community. We have simply to return to the origins. Just one example. Many national laws on arbitration and even rules of permanent arbitral institutions containing rules on time limits for rendering a verdict. Often there are just a couple of months time limits. Naturally, such laws and rules contain also mechanisms how to extend such time limits. However, it is obvious and logic that legislators intended such mechanisms to extend the time limits as exception. And the parties expect that the proceedings will comply with such laws and rules when entering arbitration agreements. Nevertheless, the daily practice became completely different. Exceptions became a daily practice. This indicates, at least for me and certainly for many other practitioners I'm often discussing these programs throughout the years with, that the practice is moving away from expectations of the parties. The practice is moving away from basic principles of arbitration. The only way is, from my perspective, is that arbitrators will play significantly much active role in arbitral proceedings then it became a daily practice in the past years. And this is exactly what the parties will expect now, particularly now. And this is what the parties will call right now for. Arbitration and arbitrators simply must meet these expectations and significantly adapt and change conducts of proceedings from their perspective to meet their basic duties, to meet the tasks and aim of arbitration, in particular in this specific and indeed exceptional situation. Ladies and gentlemen, distinguished colleagues, thank you for your attention. Thank you once more for inviting me to this conference, and wishing you, of course, to remain healthy, and wishing you all the best. Thank you.